From the opinion pages of the Wall Street Journal, this is Potomac Watch.
In a 6-3 decision, the Supreme Court upholds Mississippi's ban on abortion after 15 weeks, while also ruling 5-4 to reverse Roe v. Wade. What does this mean for politics and the law? Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Kim Strassel and editorial board member Alicia Finley. Welcome to you both. American politics has been roiled ever since the leak of Justice Samuel Alito's draft opinion in this case, which is called Dobbs. The Mississippi law at issue here generally bans abortion after 15 weeks, with exceptions for medical emergencies and severe fetal abnormalities. And as a reminder, Roe v. Wade protected abortion until fetal viability, which is 23 or 24 weeks. And so 6 justices have upheld the Mississippi law, 5 have voted to overturn Roe. That is pretty much what we might have guessed based on the leaked opinion from Justice Alito. But Kim, to start at the beginning, why don't you just take us through a little bit of what Justice Alito says?
Sure. This opinion is pretty comprehensive, and that is why it's a landmark decision. But it's very clear that the majority wanted to really cover all the bases here, and they did. So a huge amount of the decision is devoted to explaining why Roe and Casey were wrongly decided on the merits, the legal merits, simply pointing out what a lot of legal scholars, and by the way, even a lot of liberal legal scholars have noted all along, which is that there is no right to abortion spelled out in the Constitution, no right to privacy spelled out in the Constitution, pointing out how hackneyed those original decisions were in that they read much more like legislative prescriptions about trimesters and viability and when this can be done and when it can't than they did a reading of the Constitution and the law. So a lot of the opinion is devoted to that. They make a very good argument. There's another very good section that goes through the question of precedent and stare decisis, why in this particular situation it is appropriate for the court to overturn what has indeed been a couple of long-standing rulings. And then also, which I think is useful, especially given the reaction that you are seeing, especially from the left today, a reassurance from the court that this decision does not in any way necessarily mean the end of other rulings or decisions. In particular, they mention Griswold, which is right to contraception, Ogerbefell, which is the same-sex marriage decision, noting that the questions at issue in those cases are very different from the situation of Roe and its legal merits and its history in the Supreme Court.
Just to underline that analysis, so Alito says that the Constitution does not take a position on abortion, but the Supreme Court has also, in some cases, recognized unenumerated rights, but generally not out of thin air, Alicia. And there's a test for when the Supreme Court will recognize an unenumerated right. It will do so if that right is deeply rooted in history and tradition, is the phrase. And basically, that means it was thought to be inherent when the Constitution was drafted. And he cites one opinion called Glucksberg, where the Supreme Court declined to recognize a unenumerated constitutional right to assisted suicide. And they surveyed 700 years of history and said there's nothing in our history or tradition that suggests that the people who ratified the Constitution thought that it meant that there was a right in here guaranteeing assisted suicide. And to me, the analysis, I think, is similar here for abortion.
Right. So, I mean, liberals made a lot of hay out of this when the draft was leaked because Alito does go back 700 years and looks at common law in England and how abortions, quickening, before quickening, after quickening, how it was regulated. And he cites, these laws and sources at the time that shows that, abortion was frequently banned. And that was all the way understood even at the time of the founding. And more to that point, he also notes that when the 14th Amendment was adopted, abortion was illegal in 3/4 of states, which would suggest that this isn't a deeply rooted right in a nation's tradition or history, and essentially that the court in Roe just invented it out of whole cloth. To your point, this isn't the first time that the Supreme Court went and looked at common law. This is, the history of our originalism. And this is what the court even has increasingly been doing when it has been trying to define whether there is a constitutional right. I mean, even some of the liberals have, frequently cite sources in common law, the Blackstone Dictionary, when they're trying to support their own arguments.
Kim, before we get into the rest of these opinions and the concurrences, I wonder if I could just ask you to reflect on the history leading up to this moment. Roe v. Wade is a decision from 1973. The Federalist Society was founded in 1982, and we've had decades of the conservative legal movement and Republican presidents promising to appoint justices who would interpret the law as it was written. And is this what they meant?
It's been a very long and hard fight. And I find it notable that if you go back to 2015, 2016, when a candidate named Donald Trump was running for the presidency, there was a lot of skepticism among a lot of voters about just how conservative he truly was, given his history and background, the fact that he'd once been a Democrat. And one of the things that nonetheless clinched the votes of enough people, made them feel reassured, was when Donald Trump put out his list of the names of people that would be his top choices were he president to the Supreme Court. And for a conservative movement that for years and years had made this question of the court's makeup one of their primary voting decisions, it gave a lot of them confidence that he cared about that ambition as much as they did. And guess what? He was able to appoint 3 Supreme Court justices and give us this 6-3 majority that probably allowed this decision to go ahead. Well, did allow this decision to go ahead, given it was decided on a 5-4 and that Justice Roberts was not in that majority. But I think more broadly, I would just point out, because this decision came out not long after I was born. So for a certain generation of us, we have lived with the consequences of it. And the root consequence has been a culture war kicked off by Roe v. Wade that has escalated into so many other aspects of life, real division in the country because of the imposition of a ruling that took away from average people the right to have a civil debate at the state level about what was best for their particular states and populations. And that really enraged a lot of people, became a flashpoint for both sides. We're going to have some real fights over this at the state level going forward, but it's arguably going to be a much better way to hash this out than a Supreme Court decreeing policy.
Let me pick a couple things out of the concurrences now, and I'll start with the one written by Justice Brett Kavanaugh. And he does his usual thing of repeating some of the arguments from the majority opinion in maybe more kind and more polite terms, making sure everybody that feels respected and heard. But there's one substantive thing I get from him is that he shows his cards on a couple of potential future controversies. One of them is he says, may a state bar a resident from that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel. And he also shows his cards on this idea that the 14th Amendment is a pro-life amendment if you interpret it to include fetal personhood. Kavanaugh, Alicia, is basically saying in his view, the Constitution is completely neutral on abortion, and it really is up to the states.
I think that's 100% right. You mentioned Kavanaugh's history, and he does tend to have a more go along, get along, let's try to bring some kind of comedy to the court and kind of soften the blow, so to speak, of the decision. But I think you're right. As he said, the Constitution is neutral. It doesn't actually specify whether there is a right to abortion or not. That leaves it up to the states. And what you're going to see, to Kim's earlier point, is a lot of experimentation. I do not foresee, and maybe we'll get to this a little later, I do not foresee most states outright banning abortion. I think there's going to be some kind of compromise that is hashed out in the legislatures, limiting abortion and maybe banning it in many cases, but not making exceptions of rape, incest, or the health of the woman.
The other concurrence I would highlight is from Chief Justice John Roberts, and he was the vote to uphold the Mississippi law without overturning Roe v. Wade. And one thing, I think he is miffed by what he sees as a bait and switch here. He says that Mississippi asked the Supreme Court to take this case and said that they would not require overturning Roe v. Wade. And then the Supreme Court accepted the case, and Mississippi asked to do just that. He says the court now rewards that gambit. But he also seems to think that the court could do away with the viability line imposed under current law and uphold Mississippi's abortion ban after 15 weeks and leave the question of whether the Constitution requires any right to abortion, just leave that for another day. And Kim, I'm struck by that because it seems to me that would only prolong this political trauma that we're going through if the court said, we'll uphold Mississippi's law, we'll give no guidance to lower courts, and maybe next term or a term after, maybe we'll uphold the constitutional right to abortion, maybe we'll overturn it. Who knows? I guess we'll have to find out. I mean, that seems hard for me to imagine. Reading
the Roberts concurrence, it's hard not to think that this will one day be reread as the shining example of Roberts' tenure on the court, which has always been defined by his incrementalism. And this is one of the best examples of it that you can ever get. It was clear if you went back and read the oral arguments, you really peppered those that were defending Roe v. Wade on this question of viability. It was a big issue for him. And it's obviously a huge weakness in Roe and in Casey in that it was just sort of an arbitrary decision. And he had a lot of questions for them saying, if you want to preserve choice, what does choice have to do with viability? You've just made up that line. Why couldn't we actually instead go with 15 weeks? And so this was really on his mind. But I agree with you entirely, Kyle. I think in a way, this just would have extended the national angst over this. You would leave all of these appellate courts out there saying, okay, well, Mississippi in 15 weeks is okay. Why? What line are we supposed to draw? How? I mean, this has always been the fundamental weakness of Roe, is that it was, as I said, a court essentially trying to provide a legislative prescription, and a poor one at that. Roberts, had he got his way, simply would have left the entire appellate system in confusion. And even as it was inviting more cases to come up to the court where this would ultimately have to be decided, probably in the way the court decided it today, given the current majority. So didn't make a lot of sense, but it's very much in keeping with the way Roberts approaches his jurisprudence.
Hang tight. We'll be right back. You're listening to Potomac Watch from the Wall Street Journal.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's give a word to the dissent now, and this is Justice Stephen Breyer at his most forceful. He says, as of today, this court holds a state can always force a woman to give birth, prohibiting even the earliest abortions. A state can thus transform what, when freely undertaken, is a wonder into what, when forced, may be a nightmare. Unquote. He also says that no one should be confident that this majority is done with its work, unquote. And there he's referring to other similar precedents, gay marriage, contraception. And there's one justice, Justice Thomas, in his concurrence, who suggests the court maybe should go back and revisit some of those precedents. So, Alicia, what makes you so confident that is pretty unlikely?
Well, first of all, that's just one opinion, Clarence Thomas, right? None of the other 5 or 4 actually joined him in that opinion. He's long criticized substantive due processes, which is how the court kind of substantiated its Roe v. Wade and some of these other precedents. So this is actually what Clarence Thomas said was not anything unusual or unexpected. He's been saying this or writing this for ages. Now, to the other precedents that you do, loving interracial marriage, Griswold, which is the contraception, there are different issues involving stare decisis at hand. Some of the Justice Alito outlined in his opinion or in the ruling, the stare decisis is weakest when, addressing constitutional interpretation. But there are other factors that the court takes into consideration, like the workability. Here, Roe v. Wade just wasn't workable because there wasn't a bright line for viability. Whereas the precedents in terms of, contraception, Obergefell, same-sex marriage, there aren't the same workability issues or challenges there. Same thing with the reliance interests. Unplanned pregnancies, by the very nature, they're unplanned, so there really aren't any significant reliance issues there. On the other hand, Obergefell with the same-sex marriage or loving in terms of, interracial marriage, well, there are significant reliance issues here. You have marriages, millions of marriages, contracts that would be blown up. And so the court, and regardless of whether the underpinnings and the reasoning of those cases, perhaps they are flawed, as Justice Thomas argues, but the stare decisis, the arguments for maintaining or upholding those on stare decisis are much stronger.
Yeah, and I would point to, on the point about gay marriages, there are something, I think, according to the census data, there are something like 500,000 gay marriages in the United States, and I agree the reliance interests there are very strong. I am very skeptical that the Supreme Court would say those people can be married today and not married tomorrow in the United States. I would also point to statements that some of these justices made at their confirmation hearings about these other precedents that are pretty clear, unlike what they said, or maybe I should say didn't say, about Roe v. Wade. Here's Chief Justice John Roberts. I agree with the Griswold Court's conclusion that marital privacy extends to contraception. Here's Justice Clarence Thomas. My bottom line was that I felt that there was a right to privacy in the Constitution, and that the marital right of privacy, of course, is at the core of that. And, of course, maybe their thinking has evolved. I don't know precisely how they would distinguish this case from those other cases. But the other thing I would point to, Kim, is just public opinion. If you look at the Gallup numbers, 70% of Americans say that gay marriages should be treated by the law the same as traditional marriages, and the numbers are higher for young people, so the overall figure is just going to keep going up. And 92% of Americans say that using birth control is morally acceptable. And so there's an example, Kim, where I'm not even sure the Supreme Court is going to get the opportunity to hear a case about a law banning contraception, because I'm skeptical that any state could pass one.
The best Supreme Court decisions, or ones that end up being the most durable, obviously, are ones that settle questions on matters. And obviously, there's still some debate in this country over contraception, some debate in this country over same-sex marriage. But I think the bigger point, and one of the arguments behind taking a different look at Roe and returning this to states, is that fundamentally failed with regard to abortion. The argument, even as Roe was coming out and when Casey came out, is that this is going to settle this question. It hasn't. It's simply divided people even further, especially on the margins. And we need to remember this, for significant numbers of Americans are in the middle, where they are open to some amount of abortion, but with limits. And that is probably where a lot of things are going to end up falling. Every state will have their different approach to this. I would also note that there are still going to be a lot of options in this big country. We have already had an entire list of Fortune 500 companies that have come out and immediately said that they're going to start offering their employees stipends or pots of money to get on buses and travel outside of state if they need healthcare services, including abortions. I think I read somewhere Amazon is offering up to $4,000 for such transportation costs. There are still going to be options for people. So again, the goal of this really ought to be for this to get hammered out at the legislative level and allow us to all move forward on that basis.
But it has definitely kicked off a political fight in Washington. And let's listen to a couple clips of President Biden responding to the Supreme Court's ruling.
This fall, we must elect more senators and representatives who will codify women's right to choose into federal law once again. Elect more state leaders to protect this right at the local level. We need to restore the protections of Roe as law of the land. We need to elect officials who will do that. This fall, Roe is on the ballot. This is a sad day for the country, in my view. But it doesn't mean the fight's over. Let me be very clear and unambiguous. The only way we can secure a woman's right to choose, and the balance that existed, is for Congress to restore the protections of Roe v. Wade as federal law. No executive action from the president can do that. And if Congress, as it appears, lacks the votes to do that now, voters need to make their voices heard.
So it does seem to me that abortion will be on the ballot this fall, especially in those state legislative and gubernatorial races. And maybe this will have the effect of reinvigorating some of those state-level politics and countering the nationalizing trends sometimes in our politics. But Alicia, Biden is also calling on Congress to codify Roe v. Wade. And if the Constitution is neutral on abortion, as Justice Kavanaugh insists here, is that something that Congress has the power to do?
Well, I think the issue is the Commerce Clause here in terms of whether they can override states. I think arguably the Congress's ban on partial birth abortion ban was unconstitutional. This is an issue that is for the states to decide because it doesn't really implicate interstate commerce. If Congress were to pass a national abortion law or to codify Roe v. Wade into federal law, I think the Supreme Court would likely strike both of them down, though it would tee up an interesting Commerce Clause case to kind of hone the court's precedents, which have been somewhat fuzzy in recent years and have probably been a little more expansive than some of the conservative justices would like.
Yeah, I agree. The Commerce Clause has been stretched a lot, but this may be more than 5 justices on a current Supreme Court would allow it to stretch, but I don't expect that to change the calls in these political campaigns, these House and Senate campaigns. But Kim, we'll give you the last word. What do you make of the broader political fallout of this? It seems that Democrats think they have an issue here that can help them keep the House, keep the Senate in November. Do you think they're right about that?
I don't. I mean, it's very clear Washington Democrats want this to be on the ballot. They want to campaign on this, because it is certainly a lot happier space for them to be campaigning on than inflation or rising gas prices or shortages of baby food or any of the other things that has Americans unhappy right now. I think as more Americans absorb what this opinion actually means, because let's not forget, there's also been a lot of lack of understanding out there about Roe. There's a lot of people in America who still think that the decision to overturn Roe v. Wade means that abortion is now illegal across everywhere in the United States. That information is going to filter down and it'll become more clear that this is going to be a state level fight. I think national Democrats are going to struggle in 2 ways. One, again, I think people are going to view this as something that's a more local question to deal with their governor's races, their state legislature races, maybe their statewide office races, attorney general, for instance. That's one problem. But also, I'm just not sure that it has the staying power to vie with all of the other huge issues that the administration is struggling to overcome right now at a national level. So maybe, and it might play in some of the margins in those federal races, I'd still at the moment consider this much more something that is going to play into statewide races.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button on your favorite podcast app, and we'll be back next week with another edition of Potomac Watch.